In National Crime Agency and Hajiyeva, which is reported at 2018 One Weekly's 5887, the High Court dealt with the first ever application for the discharge of an Unexplained Wealth Order. The discharge application was heard by Mr. Justice Supperstone, who had earlier granted the order on a without notice application. Mrs. Zamira Hajiyeva is married to the chairman of the International Bank of Azerbaijan and is the beneficial owner of a BVI company which owns residential property in the UK, to which the order related. She applied to discharge the order on a number of different grounds, some of which Mr. Justice Supperstone addressed individually, and others of which his lordship dealt with on a rolled-up basis. The first submission made on Mrs. Hajiyeva's behalf related to the question of who is a politically exposed person, or PEP, within the Unexplained Wealth Order regime. The argument was that Mrs. Hajiyeva was not a politically exposed person because her family member, the husband, was not himself a PEP for two distinct reasons. Because, it was submitted, the International Bank of Azerbaijan was not a state-owned enterprise within the meaning of the provisions, and also because, even if it was, he had not been entrusted with prominent public functions by, quotes, an international organisation or by a state. The parties agreed that whether an organisation is a state-owned enterprise is a question of fact. The court was satisfied on the evidence that at all material times the government of Azerbaijan had a majority shareholding in the International Bank of Azerbaijan and ultimate control of the bank. Mr. Justice Supperstone did not find it necessary to decide on this application whether the bank would have been a state-owned enterprise if the government had only held a minority shareholding. As for the second limb of the politically exposed person submission, the court held in effect that it was based on a misreading of the relevant statutory wording, and that the effect of the reference to, quotes, an international organisation or a state other than the United Kingdom or another EEA state was not to add an additional hurdle for the NCA to clear, but rather to exclude from the provisions state-owned enterprises within the UK or in other EEA states. His Lordship concluded that both Mr. Hajiyev and accordingly also Mrs. Hajiyeva, as a family member, were politically exposed persons. In her second submission, Mrs. Hajiyeva argued that, in concluding that there were reasonable grounds for suspecting that the known sources of her lawfully obtained income would have been insufficient for the purposes of enabling her to obtain the property, the court had been led into error. On the original without notice application, the NCA had referred to the fact that she'd paid a deposit of at least £4 million towards the purchase of the property in 2009 and had then been able to discharge a mortgage of up to £7.4 million over a period of only 5 years thereafter. On the application, the original application, the NCA had then gone on to refer to the evidence that Mr. Hajiyev was his wife's only source of capital and income during the relevant period, and that he'd been convicted of offences of fraud and embezzlement arising from his tenure at the bank, and again that he'd been a state employee for more than 20 years, and it was submitted that it was unlikely that such a position would have generated sufficient income to fund the acquisition of this property. On her application to discharge the order, Mrs. Hajiyeva criticised that analysis, arguing that the NCA had seriously mischaracterised her husband's role, had been wrong to place reliance on his conviction in Azerbaijan, and had not established this so-called income requirement to the requisite standard. Mr. Justice Supperstone rejected those submissions in their entirety. He found that it had been correct to proceed on the basis that Mr. Hajiyev was indeed a state employee. he wasn't persuaded that the evidence demonstrated any flagrant denial of Mr. Hajiyeva's right to a fair trial, and he noted in any event that there was no general exclusionary rule that prevented a court from relying on the fact of a conviction, even if it had been obtained flagrantly unfairly. He noted, in fact, that any general exclusion was limited to cases of torture, which this case was not. And Mr. Justice Supperstone found, finally, that there was, in any event, evidence of misuse of bank funds independent of the conviction. Specifically, his lordship referred to the fact that in the 10-year period between 2006 and 2016, Mrs. Hajiyeva had spent more than £16.3 million at Harrods in London, using 35 different American Express, MasterCard and Visa cards issued to her by the very bank of which her husband was the chairman. The next ground advanced in support of the application to discharge the order was that a penal notice contained within the Unexplained Wealth Order ought not to have been attached, because it was submitted, Parliament had set out exhaustively within the statutory wording of the Act the consequences of non-compliance. The Court gave that submission pretty short shrift, holding that the statute did not oust, either by implication or otherwise, the Court's power to attach a penal notice to an unexplained wealth order and thereby to enforce compliance with such an order through committal proceedings. The Court noted, amongst other things, that if the applicant's submission were correct on that point, it would leave what it called an enforcement gap, in that, for example, a third party might be able to assist a respondent in undermining the order by destroying documents. Next, the Court rejected a freestanding submission that the Unexplained Wealth Order offended Mrs. Hajiyeva's rights to the peaceful enjoyment of her property, holding that it represented no more than a modest and proportionate interference. The judge noted that the consequence of the order was merely that she was being required to provide information about a single residential property in which she herself lived and had lived for a number of years, and against a background where she had previously informed the Home Office that she was the beneficial owner of the BVI company, which was the registered proprietor of the property. As regards Mrs. Hajiyeva's next submission, that the Unexplained Wealth Order offended the privileges against self-incrimination and spousal privilege, Mr. Justice Supperstone noted that neither she nor her husband had a right to invoke either privilege on the basis of an alleged risk of prosecution for offences outside the UK. And he went on to find that the evidence in his view did not disclose a real and appreciable risk that either she or her husband would be prosecuted for offences in the UK. He noted, for example, that she had not identified which answers to which questions she said might incriminate her. He took the view, as well as a matter of law, that Parliament, in creating the Unexplained Wealth Order regime, must necessarily have intended that the privileges be abrogated, and in any event, he held, the fraud exception would have applied. The final ground advanced for discharging the order was that, given all the circumstances of the case, the Court ought not to have exercised its discretion to make the Unexplained Wealth Order. Unsurprisingly, given his Lordship's findings in relation to the other grounds of the application, Mr. Justice Supperstone held that none of the matters raised, whether individually or cumulatively, led him to the conclusion that the order ought not to have been made. The application was dismissed, and for the moment, and pending an appeal or further application, the Unexplained Wealth Order against Mrs. Hajiyeva remains in force.